In this lecture, we shall continue with our discussion on the overview of contract law in Ghana. And then we shall begin with intention to create legal relations. Intention to create legal relations. This topic, the entire topic, can be summarized into just about 3 or 4 sentences. The first point that we have to note is that an intention to create legal relation, it is indeed part of the elements of a valid and a binding contract. It is part of the elements of a valid and a binding contract. So the first point that you have to note under this particular topic is that when the parties themselves have agreed that they don't intend to be bound by legal relations, then the court will give effect to that particular intentions. When parties themselves have agreed, so if you are going to sign an agreement on your own with a person and you have mentioned that you don't want to be bound by legal relations, the court is supposed to give effect to that kind of intention. And remember the cases that you have to look at in that particular regard. You have the case of Rose and Frank. Rose and Frank versus Crompton Brothers. And you have the case of Jones versus Vernon Pool Limited. You remember this case of Rose and Frank Company versus Crompton Brothers. 2 parties signed a contract and they added a clause that excluded enforceability for its breach. The court held that the parties could exclude the enforceability of the agreement and that there was no intention to create legal relations. Jones and Vernon Pools Limited. You remember that case also, when there were some pools that the people had, coupons that the people had sent in, and the information on the coupon was that all the arrangements are binding in ANA only. The court held that because of that statement, binding in ANA only, the football coupons, they didn't create an intention to create legal relations. That's why the first principle is that when the parties themselves have agreed that they don't intend to be bound by legal relations, the court will give effect to that intention. And the authorities are Rose and Frank Company versus Crompton Brothers and Jones versus Vernon Pools Limited. Take note of these cases. What if the agreement is silent on whether they intend to be bound by legal relations or not? Many a time when we enter into agreement, we are silent on whether there should be an intention to create legal relations or not. The principle is that where there is no express exclusion of the intention to create legal relations, then the court will consider the nature of the agreement, its terms and conditions, surrounding circumstances, to determine whether indeed there was an intention to create legal relations or not. So take note, where there is no express exclusion of the intention to create legal relations, the court will consider the nature of the agreement, its terms and conditions surrounding the agreement to determine whether an intention to create legal relations can be inferred. Then again, bear in mind, to guide the court, usually we look at whether the agreement was in a domestic setting or it was in a commercial setting. What is the presumption that applies in domestic settings? The presumption is that if the agreement was concluded in a domestic setting, then the presumption would be that there was no intention to create legal relations. So if the agreement was concluded in a domestic setting, then the presumption would be that there was no intention to create legal relations. So which cases would you see this happening where there was in the agreement was entered into in a domestic setting and therefore there will be no intention to create legal relations? Remember the authorities of Coward versus Motor Insurance Bureau. I believe you remember Coward and Motor Insurance Bureau. Coward and Motor Insurance Bureau, that is the case where they were friends. One person wanted to be a premium passenger, that when you are going in to work, they will sit in your car and then you will be going with us. And you remember that case? Coward and Motor Insurance Bureau. Once the agreement was in a domestic setting, there was a presumption that there was no intention to create legal relations. Remember the case also of Balfour and Balfour. That case just when it's about a husband and then a wife. Remember, there'll be a presumption that there was no intention to create legal relations. But remember merit and merit. For merit and merit, even though the couple, they were married, they were separated, and therefore they were not living in amity. And therefore the court held that because they were not living in amity, there'll be a presumption that they intend to be bound by legal relations. What about agreement between a parent and then a child? If it's a parent and then a child, the presumption is that they don't intend to be bound by legal relations. Remember that case of Jones and Pada Vatten. So please, any agreement that you see in a domestic setting Once it's in a domestic setting, then the presumption will be that there was no intention to create legal relations. But remember, that presumption is rebuttable. And therefore, even though it could be an agreement in a domestic setting, if you can tell that there was a commercial flavor attached to the transaction, then the court will say that the presumption has been rebutted, in which case there will be an intention to create legal relations. I believe, remember the case of Simpkins versus Payee, Simpkins and Payee, that even though it may be in a domestic setting, if you can infer that there was an intention to create legal relations, then the presumption will begin to have been rebutted. Remember also that case of Hammer and Sidway. Remember this case as well. An uncle speaking to a nephew and telling him that if you will stop smoking, you will stop drinking and cursing and swearing, I'll pay you this amount of money. It was in a domestic setting, but the court held that the agreement will be legally enforceable. So bear in mind that I'm saying that in a domestic setting, it's only a presumption that the agreement will not be intended to create legal relations. And you have the authorities there. Coward and Motor Insurance Bureau, Balfour and Balfour, Merit and Merit. But remember Merit and Merit, that even though it was a husband and a wife, because they were separated, the presumption was rebutted because they're not living in what? In amity. Remember Jones and Padavatin, father and child. The court would hold that there was no intention to create legal relations. Remember Simpkins and Payee, that even though it was in a domestic setting, if you can see a commercial flavor, we will say that there was an intention to create legal relations. What about if the agreement is one concluded in a commercial setting? What is the presumption that applies in that particular case? If it's a commercial setting, the presumption is that there was an intention to create legal relations. And what case would you use to support that particular point? In the case of Edwards versus Skyways Limited. So as for this topic, you can summarize everything in just about 2 or 3 sentences. One, that once we have agreed that there is no intention to create legal relations, the court will say that there was no intention to create legal relations. While we have expressly agreed, you know the case over there, Rose and Frank Company versus Crompton Brothers. You also know the case of Jones versus Vernon's Food Limited. That's where we have expressly agreed that we don't intend to be bound by legal relations. What if we are silent? How will the court find out? Hammond and Elusin. We must look at the entire circumstances to determine whether there was an intention to create legal relations or not. Now, let's come to domestic and commercial setting. Domestic setting, what is the presumption? There's a presumption that once the agreement was in a domestic setting, there will be no intention to create legal relations. Authorities, Howard versus Motor Insurance Bureau, Balfour and Balfour, Jones and Padavatin, Hammer and Sidway. But this presumption is rebuttable. How can it be rebutted? Look at the case of Merit and Merit, that even though it was a husband and wife, they were not living in amity, so the presumption has been rebutted. And also look at Simpkins and Payee, even though it was in a domestic setting. If you can see a commercial flavor, the presumption will be rebutted. Then finally, commercial setting. What is the presumption in that case? The presumption is that there was an intention to create legal relations. This is the end of our discussion on intention to create legal relations. Bear in mind that even in a commercial setting, if you have expressly put over there that you don't intend to be bound by legal relations, the court will give effect to that intention. This is the end of intention to create legal relations. We shall move on to the next element of the contract. Thank you.